speaking of the old system, how did it all begin? What's the genesis of EU sanctions? And maybe we should be talking about restrictive measures. Could you take us back to the very beginning? Where do they come from? Why were they adopted? And what prompted the EU, or which world events prompted the EU to go down this route?
You are listening to This Month in EU Sanctions, a podcast at the crossroads of EU law, business, and foreign policy. I am Jan Dunin-Wasowicz, your main host. In This Month in EU Sanctions, we'll discuss all things sanctions, export controls, and trade compliance from an EU perspective. In addition to a monthly selection of legal, regulatory, and policy updates, each episode will discuss a topic of particular interest or feature a conversation with a guest. At a time of great uncertainty, the podcast seeks to offer clear information and insights, bringing together people who make, practice, or study modern European security law. After 3 months of great uncertainty concerning the future of the Russia sanctions coalition, a limited opportunity seemed to emerge in the course of April 2025 to find renewed policy convergence. The EU and the US, working independently on potential new measures, announced that they could adopt additional and coordinated sanctions to increase pressure on Russia to accept an unconditional ceasefire in Ukraine or police compliance with such ceasefire. While discussions were developing quickly and the details of the measures unclear, these developments continued to underscore the heightened policy volatility underlying the Russia sanctions. Meanwhile, in April 2025, the Council of the European Union took several actions under the Iran, Libya, Myanmar, and Moldova programs. Concerning Iran, the Council imposed sanctions on several individuals and entities responsible for human rights violations in Iran. It also extended the sanctions program for 1 more year. Concerning Libya, the Council implemented a United Nations Security Council resolution amending the scope of the sanctions against Libya, both concerning the embargo and the asset freeze measures. Finally, the Council extended the Myanmar and the Moldova sanctions regimes for 1 more year, respectively. On the compliance side, the European Commission updated its FAQs on sanctions concerning Syria, discussing, among other things, the scope of the suspension and several other questions. And later in the month, the Commission published several FAQs related to the provision of services under the Russia sanctions. On the export control side, the Council amended its common position defining common rules governing the control of exports of military technology and equipment and approving conclusions on the matter. The Council added, among the criteria for licenses, various commitments and factors to be taken into consideration, such as the risk of circumvention of EU sanctions and the risk of aggravating conflict, violence, and illegal activities. The common position specifies that member states may use other end-user monitoring tools, including requiring end-users to agree to specific verifications mechanisms. On the dual-use export control side, on April 8th, the Commission published a recommendation aimed at improving the coordination and effectiveness of national control lists of dual-use items, which member states of the EU can adopt under Article 9 of the dual-use regulation. On April 1st, France introduced additional dual-use controls related to quantum computing, and on April 7th, the Netherlands amended the Strategic Goods Decree, revoking license NL002, and introduced restrictions concerning exports of certain sensitive products to Israel. You can read more about these and other developments in the April edition of the newsletter. I'm thrilled to welcome our next guest, Jan Lepeu. Jan is a PhD researcher at the European University Institute Department of Political and Social Sciences in Florence and a lecturer at Syracuse University. His research and teaching specializes in international sanctions and EU foreign policy. A graduate of the London School of Economics and Political Science and the College of Europe in Bruges, Jan has worked for various NGOs, think tanks, and international organizations. Jan is finishing a thesis titled I Sanction, Therefore I Am, a genealogy of the emergence of international sanctioning as an EU foreign policy practice. Jan's most recently published an article in International Politics about the role of the European Commission as architect of EU foreign policy. I enjoyed speaking with Jan about the past, present, and future of EU sanctions. Hello, Jan. Welcome to the program. Thank you for joining.
Thank you very much for having me on. It's a pleasure to be here.
When I perform training and awareness sessions, when I teach EU sanctions, I like to begin with this notion of time and space. The world in which EU sanctions were born was obviously very different than the world we live in. How did you come about researching this field, and what is the significance of the historical perspective?
I think it's a fascinating moment to look at EU sanctions, and I think that for maybe two big reasons. The first one is the salience of EU sanctions in the European public discussion. I started working on EU sanctions just before the full-scale invasion of Ukraine, a year before that, and people at the time were telling me, well, is there really that much to look for in EU sanctions? It's a rather minor instrument, it's mainly for show, and nobody really cares about them. And so what's really the reason to look at them? And I already thought that there was a very interesting lens to look at very different things about the European Union, about the era of world politics we live in, and so on. But clearly, the full-scale invasion of Ukraine propelled sanctions into like the very core of the political and public debate at the European level. And on my personal experience, it went from like a rather niche topic to like a topic everybody wanted to talk about. So I remember like kind of having phone calls of journalists, and I think like most people working on EU sanctions at the time were in the same situation, because suddenly a lot of people that didn't really care too much about sanctions before became like extremely interested in sanction. And I think maybe the second element that's quite interesting about our time is that like in a sense, we live like I think for at least through the European lenses, a different era of world politics, which is really came to fruition through the full-scale invasion of Ukraine. And what some might call like the return of like tragedy into like a world history. I mean, obviously that's, I guess, a quite Eurocentric like perspective, but like I think from the perspective of Brussels, that's very true. And that also says a lot about the sanctions, because I think initially EU sanctions have been developed in a very different era for very different purposes than to help Ukraine withstand a war of aggression on its own territory. That's not why like European sanctions were designed. And I think that's also why we've seen a lot of very interesting things in terms of sanctions after the full-scale invasion.
Before we go back to why does the EU have sanctions, or how did the EU start adopting sanctions, could you remind us how today, in the spring of 2025, generally speaking, EU sanctions are made?
Well, it became actually a more complex question than it used to. And here I go back to the watershed moment of February 2022 and the full-scale invasion of Ukraine. It used to be the case that European sanctions were really part of what we call the intergovernmental policy-making mechanisms inside the European Union, meaning that it was a foreign policy instrument, and that foreign policy in the European Union works very differently than other aspects of policy-making. And when we discuss European Union, there is always this old quote of Kissinger, which actually might not have been said by Kissinger, but it's one of those quotes that's so good that people want to use them all the time, including me, I'm afraid, which was like, when I want to call Europe, who do I call? And so we have a succession of different treaties that try to answer this question. And the sense was, after the Treaty of Lisbon in 2007, there was an answer to be given to that question, which was that the president of the European Council would be the head of state interlocutor on foreign policy matters, so what we call CFSP in Europe, the Common Foreign and Security Policy. And then if you wanted to have someone with more hands on the ground, you could reach out to the HRVP, which is this High Representative for Foreign Policy, and also holds a seat of vice president inside the Commission. The idea was that those two characters were quite separated from the rest of EU policymaking. The Commission was really the driving forces, but it was different for foreign policy. And that, to a large extent was also the case for sanctions making. So the way you would do sanctions was that you would discuss it among the 27 member states in regional working groups. So those are experts on certain areas and certain themes among the delegation to the European Union. They would kind of like discuss first a little bit, should we take sanctions? Who do we sanctions? And so on and so on. Start discussing names. And then you have like an architecture of like those groups that kind of go up and up until something we call the Foreign Affairs Council, which is like the meeting where like all the foreign affairs ministers meet. And they have like the legal power to adopt such sanctions. So it was really like something that was in the hands of the member states. At the European Union level, among the Brussels institutions, the one institution that was kind of like helping them with this task was on the one side, the legal advice coming from the Council, and on the other side, the kind of European External Action Service, which acts a little bit as the foreign ministers of the European Union. In all of that, the one actor that I've not really mentioned is the European Commission, which, because it was a foreign policy tool, was not really in the driving seat. That way of making sanctions was also linked to the type of sanctions that would be adopted. So historically, most of the sanctions regime adopted by the European Union since the early 2000s have been lists of people and entities, often quite short lists. So you would have, for example, sanctions against Zimbabwe, where the idea was not to sanction Zimbabwe as a country, not to make civilians in Zimbabwe paying the price, but just to sanction some people at the head of the regime that we thought were the culprit of the misbehavior we wanted to punish. And so to know how to sanction those people or who to sanction, what you really needed is kind of expert on those countries and people that knew quite well how like the kind of the economical dynamics in those countries were working. And those people you can really find mainly in the member states. So those are diplomats or sometimes intelligence analysts. But those are people that know very much how Zimbabwe works as a country, who's responsible for what, and so on. What we see now with the type of sanctions we adopt against Russia is that they are taken in a very different way. And one of the reasons why they're taken in a very different way is that also the knowledge and the expertise you need to take them and to draft them is very different. So you don't need necessarily, you still need a lot of expertise on Russia, but the sanctions are so important for the European economy and for the European policies that you need a lot of understanding of how the European Union itself works, how the single market and all its policies work. And this expertise is not necessarily among the diplomats of the member states. It's not an expertise that intelligence analysts really have. It's an expertise that like people working inside the Commission have. And so that's a very different state of play now.
It seems that one of the hallmarks of the 2022 Russia sanctions, and in particular the initial rounds of EU sanctions in 2022, is that there was a lot of coordination and preparation that went into it. Where was that work done institutionally? It seems that the Lisbon Treaty architecture notwithstanding, that work did not happen with the President of the European Council. So who was driving that effort and why did it happen this way?
So the one actor like driving most of the drafting of the sanctions, and I want to insist on the drafting because the adoption is still done in the same way it used to be done, meaning the Foreign Affairs Council, so the ministers of the 27 member states still have to vote and by unanimity on the sanctions. But the question is not that much who votes on the sanctions, but who draft the sanctions instrument they vote on. And that is quite different now, at least for the Russia sanctions. The first three packages of sanctions that were adopted just before the invasion and just after the invasion. So before the invasion because of the recognition of the two separatist-like provinces in Ukraine. And after the invasion as like a kind of a short like term like punishment of Russians' aggression. Those were like mainly prepared by the European Commission itself. One of the reasons at the time was the need to have like quite a high level of secrecy because the idea was like to prepare at least some of those packages as deterrents. So kind of like letting like the Russian a bit guessing what might come their way. And one thing we know in Brussels is like if you start kind of having a document that's kind of like sent to 27 member states, the diplomats and so on, that's a lot of people like in CC in the emails, if I can say. And there is a high chance that either it kind of lands on the desk of a journalist or it lands on the desk of like a diplomat or an intelligence analyst from the country you want to sanction. So like I think the requirement of secrecy explained a little bit. It doesn't mean that there is no kind of coordination, but it was mainly like coordination inside the European Commission. And it landed directly like at the ambassadorial level, like for the member states. So that's through like what we call like COREPER, which is this kind of like meeting of European ambassadors that meet like kind of weekly in Brussels, and is really kind of the train station of every kind of like European acts. So everything goes through them, and they are like kind of really the expert in all of that. And so like all the working groups and so on I discussed earlier, none of that like was like really involved in the preparation of the 3 packages. And the sense was like really they needed to be adopted like as soon as possible, because that was kind of like the political need was to send like a strong message very rapidly. And therefore, kind of like rapidity was like kind of the proof of the seriousness of the European Union. So it meant that for the first 3 packages, basically the member states didn't really have a say on the sanctions, despite the fact that legally they're the one adopting them. And they just received the package and they said yes, no. And there was really a lot of pressure to say yes, which is why you also find in some member states that complaints that the first 3 packages were not drafted very well, and because you don't have the same loop of feedback with the member states that you normally have, where you send the text to the diplomats in Brussels, which then send them to the treasuries and other kind of entities at the national level in capitals that have like the expertise to kind of like look at those texts, and then they come back and then they discuss it with the relevant European institutions. And so that's a kind of a long process, but it's also like a process that kind of like makes sure that everybody that knows something about those different like sectors that are being sanctioned is like in the loop.
How much of this do you think will now be permanent or institutionalized in practice, so to speak? Do you think this was an ad hoc solution to an exceptional situation and an exceptional problem, or has this altered the balance, and even if it's not written, the way, the process, the methodology according to which sanctions are prepared and adopted moving forward?
I think that's a very interesting question. And I think the first thing to underline here is that the Russia sanctions post-2022 were very different in how they were adopted and what was inside the sanctions, but they were not completely new. We already saw some level of those kind of dynamics happening in the past. And basically what you have is like twin dynamic between the content of the sanctions and the process through which the sanctions are designed. So what we see since the early 2010s was kind of a move to more sectorial sanctions adopted by the European Union. So you can see that in some of the sanctions adopted against Iran, in the context of the nuclear program. You can see that in some of the sanctions adopted against Syria. And you can see that in some of the sanctions adopted in 2014 and 15 after the annexation of Crimea and the start of the separatist war in Ukraine. You already see some level of like involvement of the European Commission in the drafting of the text. And that is because like we see the first kind of like move towards kind of the increasing use of sectoral sanctions that affect directly like the single market and its functioning. And so there's the need to have like kind of the expertise of the Commission in the loop. I think the main question here is the content of the Russia sanctions a one-off, or is it going to become a template for like further sanctions in other cases? And if it's the second, I would assume, like based on my own research, that the Commission will retain like a very important role there. If we go back to the Russia sanctions, what happened after the 3rd package is kind of a in-between kind of system a little bit. So that's what people in Brussels have called the confessionals. And here, basically, the member state would be consulted, like during the design phase of those sanctions, but they would not be consulted through the working groups of the council and the kind of the usual process. They would basically go one by one or like in small groups to the Commission's office to discuss with the Commission's Secretary General about the content of the sanctions. And most of the time, they didn't really have access to the text itself. They would just test red lines. So would you be happy with sanctions on that type of products? Do you want to go further? Is that kind of off limit for you? And so on and so on. So more kind of less scripted conversation and not a negotiation on the text itself. The text was still being drafted mainly by the Commission. It's just that they were doing those kind of they would just consult member states from time to time. And that's mainly what we still are in now, which is in between system, which is not going back to the intergovernmental system that used to kind of like govern how sanctions were like drafted, not like kind of completely the Commission doing it by itself behind closed door, but in between system where like the Commission still remains very much in the driving seat, and the member states kind of just have to kind of like from the outside kind of like voice their opinions. So you also saw like some of the member states told me, oh, now we draft like those kind of non-papers, like unofficial documents that they send to the Commission, telling them a little bit what they do and so on. But you see the difference a little bit. They used to be like kind of in the meeting with the pen holders about all those kind of decisions and regulations would be drafted, and now they have kind of to send emails with memos about what they want to have in the sanctions package. The one thing that is interesting is like that state of play for now like only exists for the Russia sanctions and to some extent to the Belarus sanctions, but all the sanctions are linked to the war in Ukraine. And most of the sanctions regimes still to this day for the European Union are not linked to that, and they still like largely operate through the old system of like working groups, the Council, and the EIS kind of being the main supporting bodies at the level of EU institution.
Speaking of the old system, how did it all begin? What's the genesis of EU sanctions? And maybe we should be talking about restrictive measures. Could you take us back to the very beginning? Where do they come from? Why were they adopted? And what prompted the EU, or which world events prompted the EU to go down this route?
Yeah, so I think that's a very interesting question, and it's the main question I'm trying to address through my research, because I wanted to try to understand a little bit how like we came to this situation. And I think there is a tendency to think that like it's very natural that the European Union would adopt sanctions. It's this idea that the European Union is a value-based international actor, and therefore kind of sanctions would be an instrument that really kind of naturally fits with that. But if you look at the history of EU sanctions or EU restrictive measures, as they will be called like after Maastricht, it's quite a different story. Actually, in many ways, it was a rocky start, like European capitals and European institutions at the beginning, we're really not a big fan of like unilateral autonomous sanctions taken outside of the UN system. So I try to look back to the first case of what I call like autonomous European sanctions. I cannot call them EU sanctions because they actually predate the creation of the European Union itself. So the first case is the sanctions adopted against Iran in 1980. And at the time, we are in the context of the US hostage crisis. You have like the Iranian Revolution, you have a new government getting in power, and the old ruler, the Shah, and that's fled the country. He's very sick, and he goes to the US to get treatment against cancer. The Iranian asks the US to extradite him to Iran. The US refuses. And in this context, you have like a group of students that storm the US embassy and hold like all the personnel of the US embassy like hostage for many months. The US is obviously like outraged. And they tried to impose sanctions on Iran. They first tried to go to the UN Security Council in January, like 1980, but the USSR like kind of veto like the ability of the UN Security Council to adopt sanctions against Iran. So basically, what the US resort to is kind of unilateral sanctions from their side, and they also ask like their main allies to take sanctions against Iran. And one of the reasons why I wanted to look at this case is because those are old cases. And the good thing with old cases is that archives are now open. So you can actually go in the archives and see the discussion between policymakers, between commission officials and diplomats at the time about those sanctions.
So here we're in 1980, so it's not technically speaking the EU yet, and the composition of the organization, the communities, is also very different. Can you remind us a little bit how things looked like at the time? Because I think this was a completely different animal.
It is a very different animal. And you basically have two sets of institutions. You have on the one side the European communities, and chiefly the European Economic Community, which was created by the Treaty of Rome and is really the ancestor of the European Union, and is in charge of the common market at the time, not yet single market, so like economic integration of Europe. And crucially for sanctions, there was also like a common commercial policy, meaning you have kind of similar tax system and border system for the entire market. And that actually means it's very hard to take sanctions for one of the countries without the other countries taking sanctions, because that creates distortions inside the common market. The one thing the European communities were really supposed not to meddle with was foreign policy. So foreign policy, because it's considered as the core of like kind of the sovereign state, was like for a long time kept completely outside of the European integration main kind of like mainstream core. And it was dealt like since the 60s in another like kind of organization, which was called the European Political Cooperation, EPC. And that was a very different like animal. That was a purely intergovernmental, informal setting where like kind of diplomats from like the member states of the European communities would come to discuss like foreign policy topics. But they didn't really have like a legal existence. There was no treaty for this EPC. And like the rule was like it was just kind of a forum to kind of coordinate foreign policy rather than anything else. And so that created like a interesting institutional kind of like landscape when the Americans started to ask the European to take sanctions. Because on the one side, sanctions are foreign policy instruments. So in theory, they should not be kind of dealt with by the European communities. On the other side, it's a foreign policy instruments that rely on kind of like economic instruments, economic kind of rules. And those were normally like adopted for commercial policy by the European communities. So there was a big debate about like which organization should take the lead to discuss those sanctions. So even the question of like which meeting was allowed to discuss sanctions became like very much like politicized in 1980. And here it's really important also to remember that those two institutions, like the European communities on the one side and the European political cooperation on the other side, they're not only institutions, they're also blueprint for the future. So both symbolize a different way to do European integration. And everybody knew that there would be an endpoint where there would be only one institution. And the main question was which type of blueprint this future unified institution would have. Would it be the intergovernmental system of the EPC, or would it be the commission-centric Brussels-based process of the European communities?
So when the U.S. asked for the measures in the 1980 case, were you able to identify in your research who the U.S. turned to first? Was it a particular member state or a group of member states? Where was the landing spot, so to speak, and how did the U.S. go about finding the right people to talk to?
Well, the answer is that they were also quite puzzled about this question. Is it something to do at the European level? Is it something to do at the national level, and so on? So what they did is they reach out to everybody at the same time. So you have like those kind of diplomatic operation where they reach out to the capitals, they reach out to all the European-based like institutions, and so on, which also sometimes angered some of the member states that say, well, that's a foreign policy topic, you shouldn't discuss with the Commission about it. At the same time, the Commission was quite happy to get a foot in the door of foreign policy making. But the other aspect is that at the time, European policymakers being in Brussels or in capital, in the EPC or in the European communities, they all held a quite negative outlook on economic sanctions. So at the time, it was really not obvious for them that economic sanctions were the right answer to a hostage crisis in Iran. And that's quite interesting because if you compare it to today, you would assume that would be kind of a case for sanctions immediately. It's one of the kind of the core principle of like international public law that like kind of the grounds of the embassies are like protected and so on and so on. It's one of the kind of the most established norms of like international law. And it was kind of like very obviously violated. And so that would typically be the type of cases where the European Union would take sanctions right now. At the time, they thought that sanctions would actually be counterproductive. And what happened is like for 6 months, they negotiated with the US and tried to basically like present them a cold shoulder saying, well, actually, we will discuss it. We will take some time. So we're not completely sure about it and so on and so on. And it really took a lot of US pressure to force them to take sanctions. Basically, at the end of the day, the reason why they took the sanctions is not because they thought the sanctions would help the hostage in the ground. It's not because they thought it would protect the normative infrastructure of the international realm. But it's because they thought it would be very important to protect the relationship with the US, which at the time was the security, it still is the security guarantor of Europeans, but at the time was the middle of the Cold War, and that had a very tangible meaning at the time.
And from a European perspective, how did these measures ultimately look like?
So the way they look like in the case of Iran in 1980 was in the end, it was a EPC, so this kind of political cooperation, informal kind of like institution. It was an EPC kind of foreign minister declaration. So no kind of legal value in it. And the idea would then was that then all the kind of the member states would kind of use like national instruments, kind of like rules and laws like from the kind of either adopted by the executive like branches or the legislative branches at the national level. So those would be like the tools through which the sanctions are actually made into law. But there was very soon a problem. So the British, which was actually by the end of this period, like the one actor really trying to push the European to take coordinated sanctions, actually like the British Parliament was very unhappy about the sanctions, and they watered down the sanctions to a large extent, which meant actually like the kind of the sanctions that were like kind of agreed upon like at the European level were not kind of implemented in a similar like kind of fashion all around the European common market, which quickly kind of created new problems.
It's very interesting, if I could just pause here for a moment, because jumping back from the 1980s to 2025, there is now, I think, a certain degree of anxiety about the renewal of the Russia sanctions in July of 2025. And I think both of us have seen or heard various options under consideration should the Council not be able to find unanimity. And I think one of the options or the plans being floated would basically to have the member states, the 26 member states that agree on the renewal, adopt some kind of document at that level, and then have the 26 member states of the EU extend those measures independently at the national level through national legislation. It sounds like, based on your 1980 example of what happened with the British Parliament, that this might not be the right way to go.
I mean, it's clearly a suboptimal way to go. And I think even the people planning for that would be happy to concede that. And I think probably to this point, it's more kind of used as a last resort instrument or like a tool in negotiation that really an option people would consider for real, because it creates all type of problems. Because once you have a single market with common policies, it creates kind of distortion. It means that like some goods possibly kind of are allowed in some countries and not other. But if there is no border checks inside the single market, how do you account for that? And that's only for like trade in goods, which is probably the easier aspect of all those rules and regulations. So yeah, I think what we learned from that case is that creates a lot of problem. And that's actually what we saw, what we see throughout the 80s is a kind of changing practice where slowly the European Union, or the European, not European Union, but the Europeans all together started to rely common commercial policy instruments and kind of actual European level regulations to have the kind of legal certainty and clarity that all the sanctions would kind of be implemented in quite similar fashion across the common market. And that's what you really see in 82 in the case of the sanctions adopted against Argentina. And here you see a very interesting I think precedent, because basically what you see at the time is you have this kind of discussion between member states between using the EC kind of commercial policy instrument and using national instruments. And basically every time sanctions are on the table, those kind of discussion starts again. And in this case of the Argentinian sanctions, what you finally reach is a compromise. The EPC, so that the intergovernmental body in charge of foreign policy, would first take a common position that would then ask the European community to then take a regulation. And basically what you see here is the ancestor of how sanctions still work to this day in the European Union, which often people wonder why we still need two different type of texts being adopted at the European level for most sanctions today. This moment where this compromise was found between the people that wanted to keep it purely outside of the remit of Brussels and the people that wanted the certainty of the Brussels instruments.
And unless I'm mistaken, I think the sanctions adopted against Argentina were amongst the first ones that had trade sanctions, right? Because there was a fairly comprehensive import ban on Argentine origin products into the communities. And looking back at this example, I was wondering whether that the nature of these restrictions may also have been one of the reasons that the commercial policy ultimately served as a predicate for the measures.
Yes, but I think actually it might be slightly different in the content of the sanctions, but I think it's more the learning curve that led to this point. So what happened a few months before is that some sanctions have been adopted against the USSR because of the martial law in Poland. And at the time, the consensus was still largely not to use commercial instruments. There was a problem, which was that Greece just joined the kind of European integration mechanisms, and Greece was completely against sanctions. And they actually realized that using commercial policy instruments meant that they could outvote Greece, which was not the case for an EPC declaration, which required unanimity. So they adopted like kind of a first kind of set of commercial policy instruments a few months before. But at the time, the idea was really, okay, this is not a precedent. This is just a quick fix to a temporary problem. We have one member state that's completely against it. Again, you might have some parallels to make here with more recent cases. But there is a learning process. And once that was adopted for a very specific reason, then the next time people say, well, actually, we did it last time, we should do it again. And so that's how you reach this Argentinian compromise of saying we will use an actual kind of European community regulation and not just kind of a common statements of foreign ministers.
So the sanctions against Argentina, in other words, this would be the first example where you have both the foreign policy instrument, the foreign policy document, which today we'd call the decision, and then the regulation. And how does it go from there after Argentina?
Well, from there, it doesn't settle completely the question right away. The big sanctions discussion for the next few years are about South Africa. But what you see is like the more far-reaching sanctions against South Africa, which are adopted in 1986, they follow the Argentinian model of having like an EP decision, which is the ancestor of the council decision today, and like a commercial policy regulation, which is the ancestor of the regulation we have today for sanctions. So that's really the moment where this model solidifies. And then you arrive to the negotiation of the Maastricht Treaty. This time, all those kind of practice that were not really codified into law will be turned into articles that almost have a constitutional value at the European level in the European treaties, in the Maastricht Treaty. And that's this Argentinian model that's then at this moment put in writing.
And before we move to the Maastricht era, so to speak, I wanted to ask you something about the UN, because it seems that in the Iran case, the US came to Europe in 1980 because it was unable to achieve its desired policy objective within the UN system. And there is this discussion which isn't completely closed on multilateral sanctions, unilateral sanctions, autonomous sanctions. In the 1980s, where the EU was taking actions following the events in Argentina, following the events in Poland, was there any discussion within Europe, within the communities, about how that regime relates to the UN system and whether it was not necessarily appropriate, but whether everyone felt comfortable proceeding with these types of measures outside of the UN system and in the specific European interest?
Yes, very much. Actually, when I said that in 1980, most Europeans were quite skeptical about imposing sanctions on Iran, I should have been more specific. They were skeptical about imposing autonomous sanctions on Iran. Actually, the countries that were then in the Security Council all voted in favor of the resolution that would have imposed sanctions on Iran. But the problem was a classical Cold War dynamic of a UN Security Council being blocked by this rivalry between the Western and the Eastern Bloc. And so that's the context in which European autonomous sanctions are then created. Well, on most topics, the UN, which is the body that's been legally empowered to take those sanctions and have the legitimacy to do it in the name of international law, in the name of the entire international community, on a clear legal basis, is not functioning properly, or at least that's the kind of understanding of the Europeans. And actually, when the Americans asked them first to take sanctions against Iran, what they do is they set up like a working group of like international lawyers, try to understand what would be the legality of like autonomous sanctions. And for them, it was very unclear that actually those sanctions were like very legal. And I think to an extent, this discussion is still ongoing, right? It's a very quite complex discussion about like countermeasures and retortions and so on. But the point is that like sanctions as a political category of instruments is not really very easy to analyze in terms of international laws, and what are the limits of like what would be legal and illegal. It's very unclear. And at the time, the Europeans in the start of the 80s, the 1980s, were rather on the side of like being very skeptical about the use of sanctions. And that's something that has changed completely since then.
And that takes us to the 1990s and the very important Maastricht Treaty for the history of the European Union. Maybe one question that always intrigued me, and there's this sensitivity, maybe less, but for some time there was a sensitivity in Brussels of not referring to sanctions as such, but to restrictive measures. and I've heard various theories on why these are called restrictive measures. But I wanted to ask you, in your research, have you come across the explanation for why those actions are called restrictive measures, and why wasn't another term used? Is this something that has to do with the prevailing vision as to what these measures should be or should not be at the time? And that would be a first question. My second question, you mentioned that there was an institutionalization of a practice in the Maastricht Treaty. It was also a new era for UN sanctions. So are these two in tension? Is there a tension between the institutionalization of the practice in the Maastricht Treaty and this new era of UN sanctions?
Yeah, I mean, the irony, I think, here is that while the European Union finally kind of is created and has clear rules and mechanisms to adopt sanctions, the focus on sanctions clearly moves back to New York and the United Nations Security Council. Because the Cold War is over, and at least for the first decade and a half, there is a lot of goodwill and cooperation inside the UN Security Council. And so sanctioning and all the discussion around sanctions really happens in New York. Regarding restrictive measures, I've not really focused on that question too much, but I think the answer lies in what European sanctions were supposed to look like and what they were supposed to be contrasted with. So I think to understand the history of sanctions, the crucial element is to understand the role that the Iraq sanctions adopted in 1990 played in all those discussions. 1990, Iraq invades Kuwait, and we all remember that it leads to the first Gulf War and the UN Security Resolution that empowering the US and allies to come to the rescue of Kuwait. What we tend to forget is that actually before that sanctions were adopted, and after the end of the war, the sanctions were left in place, which meant for the entirety of the 90s, basically until the second Gulf War and the invasion of the US, sanctions were in place, and those were very comprehensive sanctions, something akin to a total embargo, at least at first. And they kind of created a very bad reputation for sanctions because basically at the time, the Iraqi state was in a desperate stage, and you had a lot of famine and lack of access to medicine and so on. And the sanctions were blamed for making all of that worse. So you had an infamous UNICEF report that calculated that sanction would be possibly responsible for the death of 500,000 children, which obviously created a big shock. But it's very clear that the sanctions led to or at least worsened the humanitarian catastrophe that was happening in Iraq during the 90s. So the entire discussion around sanctions throughout the 90s and early 2000s is about moving or changing the template of how to do sanctions. And that's the creation of what we call targeted or smart sanctions. It starts really much as a discussion around UN sanctions. It's a discussion that is very much led by European states, being EU states or other states like Norway and Switzerland, also Canada and so on. But you have middle power, Western liberal states that are really leading this process. And that leads to a change of what sanctions should look like. And again, as I said, the official aim at the time was to change how UN sanctions would be designed. But the repercussion of that was also to change how European sanctions should be designed, or at least give a different template for the future of UN sanctions. And I think the idea of calling them restrictive measures was to underline the fact that it would be quite restricted sanctions that would mainly target the wrongdoers themselves and not entire countries and the civilian population, as it was done against Iraq in 1990.
And in the Maastricht era leading up to the early 2000s, what do you think were the key moments in EU sanctions policy and practice?
So my argument is actually the key moments weirdly doesn't really happen in Brussels. It happens around New York and this movement, what we call the sanctions reform movement, which is this group of activists, scholars that creates a number of processes, meetings between UN practitioners, between diplomats in New York and in capitals, but also for the first time a broader part of the stakeholders of sanctions. So for the first time, you have discussion with big banks and other actors of the private sectors. You have NGOs and peace activists invited and so on. And so you have this weird mix of people that creates for the first time, I think, a community around the use of sanctions. And that's really, I think, when people start to describe themselves as sanctions expert. So you have in specific law firms, in specific NGOs, even inside the bureaucracies of states, people that start to specialize on sanctions. That was pretty much not the case at all prior to this era of the 90s.
And it would also explain why so much of the EU activity at the time is focused on implementing UN-driven measures.
Yeah, exactly. So in terms of like the sanctions taken, they're often taken at the UN level because there is actually now like no blocks anymore to use the Security Council, at least in most cases. And there is still kind of a double argument that's still pretty much the case now, that UN sanctions are more effective because all states inside the UN have the duty to implement them. So they're like universal by design. And second of all, they also have like more legitimacy and less contestation than like, instruments are adopted like unilaterally by like a state or a group of states. And so like the kind of the lead in sanctions making is really like kind of at the UN, and the EU starts to implement them. But they also start to codify a little bit in kind of soft law kind of text what kind of EU sanctions should look like. And really here, like it's where we see like the birth of this kind of instrument of like asset freeze and travel bans, which for a long time have accounted for a very large majority of EU sanctions. So meaning when we say the EU sanctions Zimbabwe, what we mean in practice is they sanctions a couple of people in Zimbabwe, which are not allowed to access to the EU territory. All the assets inside the European Union market are frozen, and they're not allowed to enter in financial contacts with kind of like European entities. So that's what we actually mean for a long time by EU sanctions. And that's really the model that kind of like comes out of the sanctions reforms, this idea of like targeting directly the bad guys rather than like entire countries.
And what happens next? What happens after the reform?
So we really have this model of limited sanctions adopted, but maybe some of the hopes that those sanctions will actually be even more effective because they directly target the person you want to target. I mean, that I think has been slightly disappointed by the reality. Most of the sanctions we adopt are still in place because the people we think might change behavior don't necessarily change behavior. And so what we see is that, again, under the pressure of the US, like the EU starts to kind of move back to more like comprehensive type of sanctions. They still like nominally targeted sanctions or smart sanctions because they actually kind of like are consisted of layers of quite specific kind of type of sanctions. But when you look at the entire cake and not at the specific layers, what you have is like kind of like an amalgamation of sanctions that almost become functionally equivalent to kind of comprehensive sanctions.
And an example of that would be Iran.
So Iran is really an example where the US was also pushing the Europeans to do a lot. So again, we see here that in many ways, it's kind of changed the US sanctions practice and then adopted at the European level. And so you see that against Iran, you see that against Syria, and you see that against Russia. And I would even maybe go a bit further and also say maybe it starts to also indicate that it's a change of era for European Union and for the European Union like kind of leaders, where they realize, because the targeted sanctions were really like thought as an instrument to kind of just show like that some people are kind of outside of the boundary of like acceptable behavior. And the idea was really much that the European Union, as like the paragon of international law and liberal values, was the defender of the international legal order, and so on and so on.
Which I think is quite interesting with the adoption of the EU global human rights sanctions regime, which I think is an illustration of the EU essentially using sanctions to project values and protect a certain vision of the world or advance a certain vision of the world through sanctions, and irrespective of individual situations that are country specific. That's why we call them theme-based sanctions programs or thematic sanctions programs when it comes to projecting values.
Yes, exactly. I think the global human rights like sanctions, either like the US version of the EU version or the Australian version of like the British version, are really like in a sense the peak of those kind of liberal era sanctions. But I think in the case of Iran and in the case of Russia, what changes a little bit is that now it's not about values, it's about kind of security interests, it's about core kind of national security vital interests in the heads of like policymakers. So in a sense, like it's a different problem and maybe ask for a different remedy. I think that's one way to look at like the changes in the practice of EU sanctions like since then. And I think that's like kind of in gestation a little bit, like kind of in infancy, like during the 2010s. And it's really kind of became like the core of the sanctions against Russia. I mean, now, like when you ask like policymakers, what are like the kind of the main aim of the sanctions against Russia, people are now quite transparent about the fact that it might not change the kind of the behavior of Russia. It might not be to protect like international norms. It's really about trying to weaken the Russian military industrial complex. So it's really about wartime like measures rather than kind of like peacetime.
And I think the sanctions, the Russia sanctions, more specifically, became an essential element of defining and protecting the EU's essential security interest. And so it's a part of the EU's ability to state its own views, hold its own place, and define its red lines in the broader world discussion. I think we're seeing this in the discussions with the US, that's looking at altering or changing its policy on Russia. I think once the US realized that for a potential easing or lifting of US sanctions to be meaningful, well, that would necessitate or imply that there also be a lifting or easing of EU sanctions, but that might not work if the policy interests are not aligned, and if they're not aligned, it might create tension or leverage.
Yes, and what's very interesting now, if you contrast that in historical perspective, most of the cases we discussed today were cases where the US was really the actor pushing the European to take sanctions and to keep the sanctions and to have harder sanctions. Well, what we might see in the coming months is that actually the European Union is now the one with a stronger position on sanctions. So we have almost a reverse of the dynamic that we used to have like before. And I think that's more like your field of expertise, where it's going to raise a lot of questions about compliance and implementation, because to a large extent, the EU sanctions program was born kind of in an era where like we could rely on the US to do the implementation, because the sanctions of the EU were either functionally equivalent to the US or slightly like weaker than the one of the US. And so like most kind of private actors mainly had to consider the US sanctions, and we could actually trust them to do most of the sheriff in town kind of like business.
I think one of the most fascinating things, I suppose also explain the degree of uncertainty, is that we're seeing very rapid change on three levels. We're seeing changes in the institutions, on how sanctions are prepared, adopted, on how sanctions law and sanctions policy is made. We're seeing changes on the substance. And we're finally seeing changes on the implementation and enforcement side, raising questions such as jurisdiction and the actual reach of those sanctions, and what measures and responses should be taken in cases of violations or conduct that undermine sanctions. And so with these three interconnected dynamics at play, I think it's fair to say that we're in for another very interesting chapter or chapters in the modern era of EU sanctions.
Yeah, and I think it's only the beginning of those discussions. I think you can link it also to this concept of strategic autonomy. Are we like moving towards like more strategic autonomy on sanctions and sanctions like implementation? And that might actually means also kind of changing a little bit the balance of who does what between like the European Brussels-based like institutions and the member states. And bring back like some of the discussion about kind of EU OFAC or like some type of like implementation or enforcement at the European level, rather than leaving that in the hands of the member states. I think that's one of the discussions that's going to be like central. Second discussion is also like the need to have unanimity for sanctions, which is obviously like one of the core weakness of the European sanctions, and one of the reasons why like European sanctions might not survive like sanctions relief from the US, because we live in a world where like the European sanctions need to be kind of like voted on like every 6 months or every year, depending on sanctions packages, which means that like there is an opportunity to kind of like block them regularly. And it means like one or two kind of like states might actually have the possibility to kind of like make the entire kind of like a card castle of the EU sanctions kind of crumble. And until now, they never really felt like empowered to do so. But if they feel like the US is standing behind them, then that might change a little bit the political dynamics.
On that note, Jan, I wanted to thank you again for joining me for this episode. It was a real pleasure. Good luck with your fascinating research, and I look forward to reading your next articles.
Thank you very much, and I look forward to the next episodes.
This concludes this month's episode. If you've enjoyed the show, I hope you'll consider subscribing. or writing a review on any platform you are used to. This month in EU Sanctions is also a newsletter on LinkedIn. Links are available in the show's notes. Thank you for listening, and tune in soon for the next episode.